reading the judgment on the second one.
Shergill and others, and Khaira and others.
In spring of 1987, a group of men decided to establish a Sikh temple, or Gurdwara, under the supreme authority of His Holiness Brahmigajyani Reverend 108 Sant Maharaj Baba Jan Singh Ji, the first holy saint, the head of the abode of saints in the Indian village of Johal. In September 1987, the first holy saint approved a property in Birmingham which was purchased as a Gurdwara, a Sikh temple, with a combination of donations and loans. The first holy saint delegated the management of the Gurdwara to the respondents, to whom it was then transferred. In January 1991, the respondents executed a deed of trust in which they declared themselves to be the trustees of a religious organization following the teachers of the first holy saint, the society. Clause 5 of the deed empowered the saint or his successor to remove existing trustees and appoint new trustees. In November 2001, the first holy saint died, and he was succeeded by Sant Harbajan Ji, who died in March 2002. In July 2003, Sant Jeet Singh was recognized as the third holy saint. Thereafter, Sant Jeet Singh, the third holy saint, purported to remove the respondents as trustees and to replace them with the appellants, who issue proceedings seeking various heads of relief. The respondents applied to strike out the claim. His Honour Judge Cook dismissed the application, but the Court of Appeal allowed the respondents' appeal. The Court of Appeal concluded that the issues between the parties turned on religious beliefs, which were not justiciable by English courts, so they struck out the claim. The Supreme Court allows the appellant's appeal and orders that the proceedings go to trial for reasons given in a judgment by Lord Sumption, Lord Hodge and myself, with which Lord Mance and Lord Clark agree. The issues which emerged as being likely to be in dispute were first, whether Clause 5 of the 1991 deed was invalid insofar as it purports to accord the power to appoint and dismiss trustees on anyone other than the first holy saint. Secondly, if Clause 5 is valid, whether the reference to the successor of the first holy saint in Clause 5 is limited to St. Harbajan Ji, the immediate successor of the first holy saint, or whether it extends to subsequent successors. And thirdly, if it extends to subsequent successors, whether Sant Jeet Singh is successor to the first holy saint, or whether he is unfit to be the successor. So far as the validity of Clause 5 is concerned, in Attorney General and Matheson, it was held that where a charitable trust is initially created in general or vague terms, the trustee may execute a more specific deed, limiting the terms of the trust, provided it doesn't conflict with the original terms. Where this principle applies, trustees presumably have the power to include provisions in the trust deed which they would not normally have the power to impose. In this case, the trustees may well have authority under this principle to agree a term such as Clause 5. However, it wouldn't be right to resolve the issue now, as it's not been fully pleaded, the arguments have changed and have not been fully considered in the courts below, and the resolution is very likely to be fact-sensitive. As for the meaning of successor in Clause 5, as a matter of language, it could be limited to the next holy saint, the second holy saint now deceased, or it could extend to each successive holy saint. It wouldn't be right to resolve that issue at this interlocutory stage for much the same reasons given in relation to the first issue. As for non-justiciability, generally, a case is non-justiciable where an essential issue is inherently unsuitable for judicial determination because of its subject matter. Such cases generally fall into two categories. First, cases where the issue in question is beyond the court's constitutional competence. In such cases, the court may not adjudicate on the question, even if it would be necessary to do so in order to decide another issue. An example is the non-justiciability of issues of proceedings in Parliament. The second category of cases are those based neither on private legal rights, nor private legal obligations, nor on reviewable matters of public law. While generally non-justiciable, such issues must nonetheless be resolved by a court if their resolution is necessary to decide some other issue which itself is justiciable. As for the more specific issue of religious doctrine, the courts do not generally adjudicate on the truths of religious beliefs or on the validity of particular rights. But where the court is being asked to enforce private rights and private obligations which depend on religious issues, it has to determine such issues insofar as they can be objectively assessed. Where a trust governs the purposes for which property is held, there is an interest that the civil law will protect. So the courts can determine disputes over ownership, possession and control of property held on trusts for religious purposes.